नमस्कार, आदाब, सत श्री अकाल दोस्तों। स्वागत है आपका एक बार फिर से हमारे YouTube चैनल ब्रास फ्यूजन्स पर, जहां आज हम आपके लिए लेकर आए हैं एक नया लेसन।
मैम, ओके। दास सुधीर कुमार
प्रेजेंट मैम।
नायक
प्रेजेंट मैम।
ओके। ऋषभ यादव
प्रेजेंट मैम।
ओके। लोकेश
प्रेजेंट मैम।
ओके। रूपाली प्राशर सुधांशु कुमार सिंह
यस मैम।
ओके। अमित शर्मा गौरव यादव
यस मैम।
ओके। सूर्य प्रताप देवा
प्रेजेंट मैम।
ओके। प्रियम मलिक महेश वीरेंद्र यादव प्रतीक यादव
यस मैम।
या आबिद खान
यस मैम।
आबिद ओके। माथ्यू विवेक राज अक्षय अक्षय विवेक या ओके। आई माथ्यू अक्षय साक्षी शर्मा चालू चोकर मनदीप सिंह
प्रेजेंट मैम।
या नमन मित्तल उत्कर्ष अग्रवाल जतिन सैनी
प्रेजेंट मैम। जतिन
या विकास वेदित
प्रेजेंट मैम। विकास
या राहुल पुनिया
उत्कर्ष अग्रवाल प्रेजेंट।
उत्कर्ष प्रेजेंट ओके। आई माथ्यू
थैंक यू मैम।
राहुल पुनिया सुकृति सुकृति और ऑल्सो देयर भरत कुमार प्रियशा वर्षा कुमारी अलमास
प्रेजेंट मैम।
ओके। इंद्रजीत प्रभाकरन सिमरन राय यश भारती हिमांशु भाटी
प्रेजेंट मैम।
ओके। रोहित यादव
प्रेजेंट मैम। रोहित
या रोहित प्रेजेंट। संकेत शिवम निर्भय रजत चौधरी नकुल लोहिया नकुल या तनवीन विक्रांत भामा अमीर अली चित्रा सिंह
प्रेजेंट मैम।
या दिशा बागरी
प्रेजेंट मैम।
यस अंबिका
प्रेजेंट मैम।
ओके। शंकर पासवान कुमार विनय
प्रेजेंट मैम।
यस। चेतना गौतम
प्रेजेंट मैम।
यस। शुभम वर्मा हरिहर सुदन गीतांजलि वर्णिका संगीता
यस मैम।
यस। अनुज कुमार रिंकू यस। कन्हैया अजय कुमार निखिल
प्रेजेंट मैम।
यस। सुनील पासवान
यस मैम।
यस। विजय प्रताप सिंह
प्रेजेंट मैम।
and and I realized actually maybe I mixed up Lok Sabha and Rajya Sabha yesterday because that question got triggered by that. The allocation in Article 331, 2 seats for members of the Anglo-Indian community. When the British were here, they had in fact had a policy of encouraging their officers to marry Indians, and so you have this whole lot of Anglo-Indians who were chose to remain in India, and when partition took place, they did not go away. They did not go back to England. They were here settled for. So for example, Mr. Derek O'Brien is an Anglo-Indian. There have been very well-known Anglo-Indians in the past and all over India really. But the 104th constitutional amendment, which came into force this year with effect from 25th January, okay? I'm emphasizing the number 104th because it's a mistake I also made. It had been introduced in Parliament as 116th and then actually notified as. Now look at Article 331, please, and look at Article 334 so that we're just clear. We'll just spend a minute on this and then move on. Just since the question got raised, let me fully deal with it. 331. Notwithstanding anything in Article 81, the President may, if he is of the opinion that the Anglo-Indian community is not adequately represented in the Lok Sabha, can nominate not more than 2 people in that community. Now, what is the amendment done? It has not deleted Article 331. That has not been what it has done. Instead, it has amended Article 334 and reservation of seats and special representation to cease after 70 years used to be how it was. Now, reservation for scheduled caste and scheduled tribes under Article 332 has been extended for another period of 10 years. But with regard to the Anglo-Indian reservation, which is Clause B, okay, Clause B, 334B, which had earlier was to cease after 70 years. That is, it would have ceased on 26th of January 2020. They have not given the 10-year extension to the Anglo-Indian reservation, with the result that now the ability to reserve or nominate 2 members now has been done away with regard to the Lok Sabha. Okay, so please keep that in mind. With that, let's just continue with what we were discussing. We were looking at Article 75. I don't know who had that question yesterday. I've forgotten the student's name. Is that clarified? Is that clear? The question about Anglo-Indian that one of you asked?
Yes, ma'am. My primary question was, so now the seats in Lok Sabha stand as 550, not 552, that means.
Yeah, that's true.
Okay, thank you.
Because even, the 331, when you look at, it was a discretionary power given to the president. Okay? So they have not, the amendment has not increased any more seats, and they would not have done that, because even for which seat should be reserved as the scheduled caste, scheduled tribe seat, you know that there has to be a delimitation exercise, right? And we have a delimitation commission which looks demographically, and you decide which seat should be the one reserved. So those seats have actually gone. Yes, that's true. That's true. The political implications of that, how the voting would get affected. I tried to just do a rough Google search, because your point was an interesting point. What would happen to the representativity in that sense of the Lok Sabha with 2 seats less? And I found that there has not been very much commentary about it. In fact, the articles that are there, and which are basically newspaper articles, there are hardly any legal articles that are there. Maybe you can even think of writing about that, because it's something that I find there's quite a gap in the law with regard to that. Okay? Now, let's go back to collective responsibility in Article 75(5), right? We discussed collective responsibility, and then we were looking at Article 75(5), which gives you a window of 6 months. I also made the point that unlike the English Convention, there is no law on the point, that at the starting point itself, somebody should have been a member of the Lok Sabha. But that was never accepted in India. And if you look at the 2 judgments, and I hope Vinayak, I'll just be calling on Vinayak right now, that had not ever been the practice that had been sought to be followed in India. And even Dr. Ambedkar, when you look at the debates, had said, no, let's give a 6-month window. So obviously you were willing to bring somebody from outside who within a period of 6 months would have got elected to either House of Parliament and then continued as a minister. So, this other convention, since we're talking about that, is that even if you are a minister who's a member of the Lok Sabha, you have full right to enter the Rajya Sabha and speak, because that principle of collective responsibility is that you will respond to any question in either house. Okay, so your entry is not restricted. Now, today we are looking at a very interesting point, which is those of you who have read S.P. Anand's case, which is what happens, you have a 6-month window. So I'm going to take up 2 questions. The first question which Vinayak is now going to present is, does the word minister include prime minister? And he will tell you the facts of the case. But the second issue, which is also related, and which those of you who have read B.R. Kapoor will know, what happens if for 6 months I appoint a minister, then one day before the that because the Prime Minister tells the President, I don't want this man anymore as a minister. It's his pleasure. Remember, we discussed this yesterday, 75(1), and read with Article 75(3) that there is this pleasure. He will appoint. And he resigns. He's removed from the cabinet. When after a 2-day gap, again you appoint the person as a minister. And then another fresh 6 months happens. What happens if you repeatedly do that? And this is not a hypothetical question. It has actually happened in Punjab in the 60s and 70s, where a person happily avoided seeking elections or getting elected, and every 5.5 months he would be removed from the cabinet and then reappointed once again. Is this a permissible practice? So these are the two questions that we are looking at. So I'm going to ask Vinayak. Vinayak, in a few minutes, just please, in about 15 minutes, tell us the facts of the case. And then after that, quickly run through the decision made points.
Yes. In SPNM versus HD Devi Koda, there was a division bench. The judgment is written by Chief Justice A.M. Hamdi for himself and Justice Sujata. And the moot question here is...
Justice Sujata Manohar.
Yes, Justice Sujata Manohar. And the moot question here is that whether there is a difference between Minister and Prime Minister in the section... in Article 75 of the Constitution, and the second contention that was basically whether a minister or prime minister can be appointed by the president when he is not a member of either house of the parliament or the state legislation. In the decade of 1980, the facts of this case are that Shri H.D. Deve Gowda, the then Prime Minister of India in 1996, was not a member of either house of the parliament, and he was appointed as Prime Minister of India by the President of India. And the petitioner filed a case in the Supreme Court under Article 32.
I want to just interrupt you here, Vinayak. You must also state that he was elected as the leader by the party that had been invited to form the government, right? That's how Mr. Deve Gowda was called by the president.
Yes, ma'am. Yeah. Yes, ma'am. He was leader of the party, which was invited by the president, and in that way he was appointed as the Prime Minister, and then the petitioner filed a case in the Supreme Court under Article 32 challenging the appointment of the H.D. Deve Gowda. And
I'm going to interrupt you here again. Normally we say Article 32 is a provision which is for violation of a fundamental right. This is a petition under Article 32. So, what is it that he had? Are there any particular articles that he had mentioned while filing the petition?
Yes, ma'am. Article 14, Article 21, and Article 75.
Yeah, very good. Why do you think he mentioned 14 and 21? 75 we know. He mentioned 75 because he is going to say that there is no provision for a Prime Minister. There is only provision for the word Minister in Article 75(5). Why do you think he mentioned 14 and 21? Is it only because he wanted to file it under 32, or was there a deeper reason for it?
I think, to my mind, ma'am, Article 14, because right to equality, is challenging under right to equality because it infringes the right of every other member of the parliament who is elected therein, and the president has appointed a person who is not a member of either house of the parliament.
Or could I not argue, I hope the others are listening in because I'm just having this dialogue with Vinayak, but if you have any other idea, please jump right in. The other reason is that the word 75(5) gives a 6-month window to a minister. Can it also not be argued that by reading Prime Minister into that word minister, you are actually treating unequals as equals? And that also is a violation of 14. Could that argument also not be taken that that's the reason he chose 14?
Ma'am?
Yeah?
Ma'am, maybe because reasonable classification could have been argued. in the Article 14.
How? You have to tell me what is that reasonable class?
Like because for a normal minister, no time period is given, but for to become a the 6-month period is given only for a particular individual. So this could have been argued.
No, that's not what I'm saying. 75 5 for which individual is a 6-month window given? For Prime Minister or Minister?
It is for minister.
For Minister. So if I want to develop an argument based on Article 14, what is the argument I will put forward?
Ma'am, that equating minister and prime minister on the same pedestal, because when he
Yes.
says person in whom people have not placed the confidence is allowed to occupy high office of prime minister. So isn't it derogatory on the power of prime minister, because prime minister is unequal
Right.
to equal.
So that is you are correct, Ankita. That is you are saying that you cannot in one category treat unequal people. That is also a violation of equality. And Prime Minister is a distinct category, Minister is a distinct category. So you will say that when the law is silent on that point, you should not have allowed it to. Yes, Vinayak, just please, the floor is yours again.
Yes, the facts is this, and then the contentions. There are two main contentions. One is that the Prime Minister is not a member of either House of the Parliament, and second, is there a difference between the word minister and the Prime Minister?
Good.
To this, the Attorney General of India has relied upon 5 decisions.
Good.
3 decisions are of the same petitioner, Harsharan Verma. First is Harsharan Verma versus Tribhuvan Narayan Singh. Second is Harsharan Verma versus State of UP. And third is Harsharan Verma versus Union of India. And in all the 3 cases, he has challenged the appointment of, in this first being challenging the Shri Tribhuvan Narayan Singh's appointment as Chief Minister of Uttar Pradesh. And in second is of Shri K.P. Tiwari as Minister of UP government. And in third, appointment of Shri Sitaram Kesri as Minister of State of the Central Cabinet. And the questions were, the contentions were same. And in all the 3 cases, the Supreme Court of India held that the plain reading of Article 75 says that, Article 75, Clause 5 says that a minister can be appointed and he can be elected to the either House of the Parliament within 6 months. So, by the plain reading of the Article 75, Clause 5 permits this, and all the petitions were dismissed. And in the third case that I mentioned, the Supreme Court also held that reading Article 75, Clause 5 with Article 88 also affirms this position, which says that minister can speak in either House of the Parliament, which he may not be a member, though not entitled to vote.
That's right. So just to deepen that argument of 75-5 read with 88, what is the implication therefore? Just so that others will also understand, because it's a nice little subtle argument.
I think, according to my comprehension, that it is written that any committee of the Parliament of which he may not be a member,
yes,
but shall not by virtue of this article be entitled to vote. Although he is not entitled to vote, but he is entitled to speak and participate in the debates of the either House of the Parliament.
I'm just going to interrupt you here, Vinayak. Now, that point that we had earlier discussed, that because as a minister you have right of entry into another house of which you are not a member, that itself indicates that a person has a right to be a minister even if you are not a member of the house. And using that in the Harsharan Verma's third case, Supreme Court says, therefore the word minister, this is additional quality that a non-elected minister has. And therefore, we must allow the person to be anywhere. Now, this is just an example of constitutional reasoning that you should not be just stuck on one article. We must learn to read the Constitution as a whole. So what I'm trying to do even in class is that we look at different provisions and we must familiarize ourselves with these clauses, because tomorrow when you are arguing in court yourself, see from where all they are trying to pull in arguments. So don't look at it like with a single focus, never. Cut across, look broadly across, and feel free to develop arguments, which is why the point of studying is never to only know the facts and decisions. How did they do it? What kind of argument could I have put forward using this provision? How? So that's a nice little mental exercise we should do. Okay, now come on to after the next Harsharan. Was there any argument, Vinay, in this first 3 Harsharans about a person being initially appointed should have been elected and then should have been disqualified and then only will get the window of 6 months? Are you seeing the argument I'm developing? That 75.5, I can read in 2 ways. At the time of initial appointment, you were not a minister. Right? That can mean that initially I was an elected minister, then maybe I got disqualified for whatever reason, maybe my election was set aside. I can then continue to be a minister for 6 months, but I must get re-elected. If I have such an interpretation of 75.5, at the first time when I was appointed as minister, I should have been elected in order to be appointed. Then I get disqualified, then I get a 6-month window. Did anybody try to give this interpretation? Did the petitioner give this interpretation at all?
Yes, in the first case, Harshad Verma versus Tribhuvan Narayan Singh, in paragraph 3 of this judgment, in which and to which the court said that this is a very narrow interpretation of Article 75 clause 5, and we should give it a wide.
Wide, correct. This would have been a narrow interpretation. Now look at what Vinayak and I have been talking about in the first Harsharan Verma's case. The petitioner, look at how smartly this argument has been developed. That 6-month window is only available to somebody who was legitimately elected and appointed in the first instance, then for some reason got disqualified, whatever, or his election was set aside, then he or she gets that 6-month window. Now, why I say this is, as now you are getting senior and senior law students, when you go and sit in a lawyer's office, the lawyer will most likely give you the facts of the case and say grounds likho. So if you've looked at a writ petition, you will have your petition, then you will have grounds A, B, C, D, E, F. And each ground is distinct. And you have to use your legal ingenuity, your knowledge of law, and your ability to think this way, that way, whichever way, to develop an argument. And obviously, he in his writ petition has exercised his mind and done this. So when we study, we also understand exactly. Yeah, this is a quorum of only 2 judges. Why? Because it was not seen as a constitutional interpretation case. Yeah, Vinayak. Why 21 is the question put to you, Vinayak. Why do you think he cited 21?
I think, ma'am, Article 21 says right to life and liberty, right to life, basically. So I think the petition is contending that the Prime Minister that is going to command the government is not an elected representative, and it infringes it infringes my right to life because I have not consented that person to rule me.
I see. Okay, fine, fair enough. Okay, fair enough. Now just continue, Vinayak. Yeah.
On Article 21, may I say one thing?
Yeah, who is that? 1 minute, Vinayak. Somebody is speaking. Who is this?
Ma'am, me Ankita.
Yes, Ankita, be louder and tell us.
Yes, ma'am. Yes, ma'am. Ma'am, I want to say he filed this for Article 21. Ma'am, because he mentions that in war or in peace, it is a great risk that India can ill afford to take. India cannot afford to take. Is it due to this that he filed under
Article 21? I think you're very right there that he does say that In times of crisis, parliamentary democracy is better served if we had an elected prime minister instead of somebody who is no doubt accountable to parliament but yet has not had a popular mandate in getting elected. And therefore, there is a suggestion that his credibility is therefore that much reduced. And for the high office of prime minister, while it may be good enough for minister, it's not good enough for prime minister. I think that's linked to the 21 argument. Yes. Yeah, Vinayak, please.
Then there are two persons who have separately challenged the appointment of Shri H.D. Deve Gowda in the Delhi High Court and Calcutta High Court respectively. And to the same contentions, the respective high courts have said that Article 75, Clause 5 speaks of minister and that is inclusive of prime minister also. And the Calcutta High Court said that the Prime Minister is subject to the possibility of commanding the support of majority of the members of the Lok Sabha.
Vinayak, one question to you. Suppose you were arguing on the side of the petitioner. You know that eventually the judgment says that the minister and prime minister are all minister because there is no specific provision for prime minister. So, prime minister also is a minister, only a prime minister. Right? That's what the final decision is. But suppose you were arguing against this. Suppose you had been the petitioner in this particular case. What all arguments would you develop to say prime minister is not equal to a minister?
दोस्तों, अगर आपको आज का लेसन पसंद आया हो तो वीडियो को लाइक करें। इसी के साथ अगर आपने अभी तक हमारा चैनल सब्सक्राइब नहीं किया है तो सब्सक्राइब के बटन पर क्लिक करिए और बेल आइकन दबाना ना भूलें ताकि आपको एजुकेशन से रिलेटेड नए नए अपडेट्स मिलते रहें। और अधिक जानकारी पाने के लिए आप हमारे फेसबुक और इंस्टाग्राम पेज से भी जुड़ सकते हैं जिसका लिंक डिस्क्रिप्शन बॉक्स में दिया गया है। धन्यवाद।